Hello, and thank you for tuning in to Reopening in COVID-19 Times, What Every Business Needs to Know. During this presentation, you will hear from one of Fausone Bohn's business attorneys, Brandon Grysko, as well as the president and CEO of the Michigan Manufacturers Association, John Walsh. This presentation will help you understand the policies and procedures your business should consider as it prepares to reopen to workers and the public. Thanks for watching.
We're putting this out here for purposes of your information to help you guys as you figure out how you're going to reopen your businesses and to figure out, how you're going to operate during these sort of uncertain times. But this isn't obviously attorney-client information. It's not legal advice. To the extent you need legal advice, you feel free to reach out to us over here at Fausone Bohn, and we'll be happy to help you out. So Andrea Hayden is a partner here at the firm. Like I said, she's expected to join us later on. She represents businesses, does general corporate law, land use planning and development, and different things like that. Some of you guys know me, some of you guys don't know me. I'm Brandon Grysko, an attorney here at Fausone Bohn, and I represent businesses, local government entities in labor and employment, HR, and corporate matters. I have experience negotiating employment contracts, collective bargaining agreements. I have authored numerous handbooks, policies, procedures, and represented businesses in wage and hour investigations, EEOC complaints, and other areas relating to administrative enforcement and things like that. For those of you that do know me, know that I used to be a police officer and I'm an attorney. And so during that time, I had experience dealing with workplace issues as an executive board member and a member of the negotiating team for the union. So during this whole COVID-19 craziness, I've been trying to put as much information as I can out there, trying to help the little guy as much as I can. Some of you have been following my blogs and seen some of the videos that I've done. And so I really appreciate that and really excited to be here to present on this topic.
And I'm John Walsh. Brandon, thanks for having me here today. I am the president and CEO of the Michigan Manufacturers Association, a role that I've held since January. Very happy to be there, but as you can imagine, not so happy to be on the job 6 weeks when slightly more than half of our members were shut down by the executive order. So I'm back to being happy again because manufacturing is now one of the businesses that's been authorized to move forward. And we'll talk a little bit about the details of that. Just a little more further background, I do have a relationship with Fausone Bohn. They've managed some clients from my way back past when I was a full-time practicing attorney, and I still stay in very close touch with Brandon and Jim Fausone and Paul Bohn and others, Andrea and so on. So I know the firm well. I know many of the clients. I know many of you that are participating today, and I appreciate it. Prior to being with the MMA, I spent some time in the legislature, serving Livonia as a state representative. And shortly after that, I was working with Governor Snyder as his state budget director. So more than happy to be here today. We're going to talk about some things, and we're going to leave plenty of time for questions at the end. Thanks, Brandon.
Yeah, thanks, John. And just to underscore, obviously, I think everybody's probably came here to see John Walsh. I don't know many people that came here to talk to Brandon Grysko. But John, thanks for being with us today. And John really does bring a very unique perspective, both from a legal standpoint and from the standpoint of a former legislator and somebody that obviously has experience dealing with a lot of different businesses and particularly manufacturers. So thanks again, John, for being here. And with that, we're gonna kick off our presentation here. So there's so much information out there and it's hard to keep track of it all. And part of that, of course, is that things are changing so rapidly. We've got trillions of dollars in federal aid and legislation that passed, within probably less than a 30-day period. We've got state laws that are changing, executive orders. I think as of the time of this webinar, we probably have in the neighborhood of 80 executive orders, the vast majority of which relate to the COVID-19 situation. For those in Wayne County and probably other counties, at least in the Southeast Michigan area, you also have local public health orders. I know there's at least 2 in Wayne County right now, and I'm pretty sure Oakland and Macomb County have local public health orders as well. And then, of course, there's guidelines from OSHA, the CDC. You've seen things from the World Health Organization, I'm sure. And there's plenty of other agencies and opinions out there. So it's very difficult to stay on top of all that stuff. So what we're trying to do today is really bring that relevant information to you so that you know what the good sources are to follow and how to implement these things as you attempt to reopen for business and operate in the interim while the COVID situation is going on. So probably everybody heard by now that Executive Order 2020-77 is out. This allows for the typical critical infrastructure workers that have sort of been operating from the beginning of this situation, and also those workers that conduct minimum basic operations, like things that are necessary for payroll and to maintain equipment inventory and things of that nature. What we do have now from 2020-70, and then a week later with 2020-77, is certain activities that are considered to be resumed activities. And those include things like construction, real estate services, remote and curbside retail operations, and as John said, and we'll talk about in more detail, manufacturing operations. But what I'd like to do before we get into the nitty gritty of all this stuff is I'd like to give John an opportunity to explain sort of the background of this, where it came from, where it's going, how it developed, and what some of the challenges are going to be going forward.
Thanks, Brandon. So the 2020-77 was a hard piece of work for us. We worked, and by that I mean we worked very closely with the administration and other business associations to construct a framework within which the governor could begin to make decisions on reactivating elements of the workforce. I'm going to spend my time on manufacturing when we spend a little bit more time talking shortly about best practices. Many of the best practices will apply to any industry, but I'm going to focus my comments today on manufacturing. I want to make a quick comment. Brandon has indicated that there's a lot of information at play here. We have a site, a website, it's mimfg.org. And again, that's mimfg.org. And we have a section that's called the COVID response. We have a variety of information there. It is not restricted to members. Anyone can go and take a look. It's the executive orders, it's state law, it's CDC guidelines, OSHA guidelines. We keep it up to date. So if you're looking for someplace where you can readily find information that's in a single spot, that's what we're trying to do with that website and that link rather. So the Executive Order 2020-77 allowed manufacturing to move forward. We were delighted because it changed the analysis from something that was infrastructure based, something that was required versus non-required. The wording was actually essential versus non-essential. And that was very confusing, frankly, because there are federal standards promulgated by Homeland Security, but the governor chose not to follow all of those standards. And so we spent a lot of time with members trying to educate them on what was essential and not essential. Once we got through that initial shock of manufacturing, part of it being shut down, and to put it into a context for you, manufacturing has direct employment of 625,000 employees in the state of Michigan alone. We think that more than half were sidelined by the executive order. It's difficult to assess entirely, but it affected nearly every aspect of our membership, which represents every aspect of manufacturing. So we were looking at a pretty dramatic hit to businesses and to employees across the state. And we worked with the governor to assure her and her team that manufacturing could operate safely and productively. The two are not exclusive. We think that's true for other workplaces, but manufacturing went early after construction, landscaping. And what we proposed is that a number of industries were already operating in manufacturing, considered essential, and they were operating safely. They were deploying PPE. They were staggering their start times. I'm going to go a little deeper into those things. They were doing it safely. Others that weren't deemed essential originally converted their process to making, if they had sewing capacity, they started making hospital gowns. Some started making shields. They were able to reopen and reopen safely as now an essential business. We felt the standard would be better, the state would be better served by a standard that is safe. Are your employees safe? Do they feel confident in the workplace? Do your vendors feel safe? Manufacturing obviously doesn't have a lot of customers on site, but I'll talk about some customer-related standards shortly. So we were pleased with the order overall. Generally speaking, the order does follow CDC and OSHA guidelines. We had been informing and educating our membership on what those guidelines are, how they should be prepared, and they were getting prepared to open again. But there are some spots where it's a little more particular, and I want to point those out to you. Under CDC and OSHA guidelines, the requirement for training is really left to the employer to work out with the employees. You can determine how you're going to train your employees. The Section 11K specifically in 2020-77 lists out all the things that you need to include in your training. So you want to take a look at it. They're common sense, but they are articulated. It's issues like, who should you contact if you're ill off-site? Who should you contact if you're ill on-site? What's your evacuation plan, isolation plan for somebody who does become ill on-site? The common identifiable sources for COVID, different types of those things. So it's a little more specific than CDC and OSHA guidelines, but we think still consistent. The other thing to point out is under OSHA and CDC guidelines, there's a pre-screening process. It is reasonable and easy to understand. I'm going to talk about that shortly. The governor is more particular in 11K. Right off the box, you do have to actually conduct a pre-screening process with your employees as they arrive onto the work site to ask them several questions. I'm going to talk about what those questions are shortly, but also to actually take a temperature when thermometers are more readily available in the commercial workspace. So I'm going to talk a little more about some of those differences when we talk about best practices. Just wanted to mention that there's just a few more details in the executive order for the time being that depart slightly from CDC and OSHA guidelines. So that, just a quick introduction. One thing I do want to point out, something that we were proud of, we led the effort to help on a face mask issue. There are groups, and the governor is very persuaded by them, that was suggesting wearing a mask indoors during your workday, all day, regardless of whether you're 6 feet away from somebody, let alone 25 feet away. If you're in your office by yourself, we were able to persuade the governor in the executive order to require the face mask only when employees cannot consistently maintain a 3 to 6 foot space between them. We think that's a big win for two reasons. One, there's an enforcement action likely to occur at some point as the recommendations in the executive order become codified and enforceable by OSHA. But also there's just simply an HR issue. You're going to have an employee at a workstation in a manufacturing plant, 25, 30 feet away from another employee. They might have occasional contact when parts and pieces are delivered to their workstation for continued work. But for the most part, they're on their own. Human nature, they're going to pull that down beneath their chin. They're going to take it off. It creates an HR issue that's problematic, and it doesn't improve the safety of anyone, in our opinion. So thankfully, we were successful in securing a line in 11K specifically, masks necessary only when you can't consistently maintain that 3 to 6 foot separation. So just a couple touch points, and then I'm going to move on to some of the legislative legal actions that are underway currently. The governor is operating under a state of emergency. State of emergency powers are granted by two separate laws under the Constitution. One was adopted in the 40s, quite comprehensive, and by its language, without end, frankly. The other adopted in the late 60s, so this would be after our current Constitution was adopted, is far more limited. It gives the governor 28 days to exercise emergency authority during a state of an emergency, and thereafter requires the cooperation of the legislature to move forward. The legislature feels that it has a valid role in addressing this COVID issue, which is both a health issue and now dynamically an economic issue for all of us. So the legislature is pushing forward. They have filed a lawsuit in the Court of Claims. There is a hearing tomorrow in the Court of Claims. It won't be dispositive. It won't be a final decision, but it does indicate that the Court of Claims is intending to move this forward quickly. As sadly, as many of you know, a lawsuit takes a very, very long time. We won't see a lot of relief from this, but hopefully the fact that Court of Claims is meeting tomorrow indicates that there might be a quicker review. I'll just tell you individually and as president of our association, I feel strongly that there are important constitutional issues that deserve to be addressed in terms of the powers between the legislature and the governor. These come up periodically. You can get worried and say it's infighting and it's political. It's a relevant fact for our democracy to determine periodically through the court system the appropriate use of powers. It's loud and noisy, but I wouldn't call it, in my opinion, untoward, political, or improper. It's just part of our process, part of our democratic process. The other issues that are at hand include personal rights, and there are no suits filed by the legislature, but there are some suits being filed by individuals and organizations regarding the Bill of Rights under the U.S. Constitution, regarding the ability to live your life. One specific example would include whether or not you can go and pray, that you can join your parish together, whatever service you might want to be with, and practice your right of religion. So those are underway. Those will take a little bit longer than the legislative claim, but I want to let you know that's underway. The other thing that I wanted to mention just quickly today is there is an effort underway. It's an initiative effort. It was filed by one of our congressmen, Congressman Mitchell. What he's attempting to do is secure 340,000 signatures to place before the legislature a law that is supported by those 340,000 individuals. If presented and properly certified, the legislature then has a simple thumbs up or thumbs down vote. That's all that they can do. The governor does not have any role in the initiative process. If it's voted down, the initiative then goes to the voters at the next general election. If it's voted up, the suggested law, the initiative, becomes law. So consistent with what the legislature has been up to, the recommendation from Congressman Mitchell is that the governor's powers be tailored back to the 67 law, which requires participation by the legislature in further determination. So just a couple of points on something I could spend a lot of time on. It could be a whole separate webinar, but I just wanted to give you some indication that keep your ears open. You're going to see some court action, and I think likely, highly likely, you're going to see an initiative go before the legislature in very short order. 340,000 signatures is all that's required to put that forward before the legislature. So with that, what I'd like to do is turn my attention and just let you know that until those things take place, we need to follow the executive orders that are in place. And I'm going to spend some time just talking about best practices in the workplace. If you go to the mifg.org site, check out our toolkit, you're going to find a 2-page summary of a variety of documents. We have the CDC guidelines. That's about 8 pages. It's actually really quite well written, easy to understand, and in my opinion, easy to apply in the industrial sector. The OSHA guidelines are a little longer. They are about 35 pages. The pages that are relevant to the manufacturing industry are between 18 and 25. It's pragmatic and common sense. And then we have 2 additional documents, one from Lear Corporation and the other from Magna. They both put a lot of resources into a 50-page plus document for each company. They've released those to industry. You're welcome to take a longer look at those. I'm going to give you just some summaries. Our 2-pager is just intended to get you started. But if your business doesn't have the resources to invest in hiring legal counsel to create an entire isolation plan, for instance, you can go to the Magna and Lear documents and pull out elements, and they're completely supportive of you making use of their materials. Tailor it, of course, to your entity, but it's a wonderful resource. We put that all in together with our 2-page oversight. So it's just easy for you to take a look at. The oversight breaks it down really to just a handful of things that we've been talking about in general, but I'm going to talk about each one. Pre-screening is the first. On arrival, CDC and OSHA suggest that your employees verbally or in writing certify that they have not exhibited or they don't feel any of the indications of COVID, none of the symptoms of COVID, that they haven't been exposed to COVID, that they have not, sorry, my screen just dropped out, that they haven't been exposed to COVID, that they haven't traveled recently. The CDC and OSHA does allow an employee to state to their employee that they do not have a temperature above 100.4. As I mentioned earlier, the executive order, until it is changed or replaced by rules at MyOSHA, does require the employer, when thermometers are available, to take the employee's temperature on arrival. So just make note of that coming in. When you're pre-screening the employees, a couple of issues that have come up and they may during questions, HIPAA, of course, you're going to need to be careful, be confidential, do your best to conduct the pre-screening in a manner that allows the information shared by the employee to be confidential with the employer. Make sure that the people that are doing the pre-screening have the ability and training to deal with an employee that might say, yes, I do have shortness of breath, and then find out that they do have a heightened temperature. How do you isolate that individual and make sure that they understand what it means to go home or stay home if they call? Have procedures in place that explain to them how long they should stay home, how long they should self-quarantine, and then certainly explain to them what the impact to them is in terms of your personnel policies, PTO, paid time off, whatever it may be in terms of dealing with the employee that can't come in. And we recommend it's pre-screening larger, but making sure that your employees understand it is for their safety and the safety of their coworkers that they shouldn't be on site if they're ill. So keep that in mind. Second category is social distancing. Under CDC and OSHA guidelines at present, it is 3 feet to 6 feet in the business space. 3 feet to 6 feet. We're recommending that you use any variety of training and information available to your employees to continue to reiterate that they should maintain that space to the extent that you can change up a break room, for instance. And I'm just trying to give you some common sense examples. The break room, you might want to take out some take out some chairs. Make it apparent that only so many people should be in there in addition to some signage on the wall. You might want to do the same if you have a lunchroom. But also, CDC and OSHA are recommending that if you have a lunchroom that has a buffet service, that you should go to prepackaged food service for the time being, just another level of safety. So when you look at your shop floor, when you look at your entrances, when you look at places that might be of common gathering, use signage, instruction to your employees, stickers on the floor, whatever it may take, just to remind people to maintain their space. Where during the day you can't maintain that 3 to 6 foot space, make certain that there is PPE available, the personal protection equipment. It is the employer's obligation to provide that and to instruct the employees on how to use it. So if you're going to have employees that come together for the purposes of packaging, that's a common area in a factory setting where employees might be within 3 to 6 feet, or when they're delivering parts from one station to another. Make certain that they understand what kind of PPE they should be wearing. A mask, most often, is sufficient, but depending on what your process is, the product you're building, the components that go into it, the procedure, if you're using chemicals, you might need a mask. You may need an apron of some sort. Rubber gloves when appropriate. OSHA has a particular section on rubber gloves, and to be careful because OSHA has concluded that sometimes that can give an employee a false sense of security because if they wear them all day and they scratch their nose, the glove's been compromised. They're going to touch somebody else or touch something else that might convey that. So make sure that there's training and that PPE is available. In addition to that, the fourth category is personal hygiene and cleanliness in the workspace, disinfecting of the workspace. To the extent that you can provide wash stations closer to your work floor, other than just the bathroom, if you can't, hand sanitizers, accentuate through training that people should wash their hands often, don't touch their face. Again, common sense guidelines from CDC and OSHA in keeping your workplace safe. Some of our members are going to move to a point where they've asked their employees to self-clean at the beginning and end of their shift, their workstation. It's not the only cleaning, it's just one additional step. They have to provide the disinfectant and the materials necessary to do that. But think about it for those of you that go to a gym. When you go to a gym, you got to wipe it down before you start, and it's probably a good idea to wipe it down when you're finished. At the end of the day in the workspace or in between shifts, depending on how you're running, make certain that your janitorial crew has upped their game, that they're using proper disinfectant. CDC and OSHA provides guidance on what to use for the purposes of disinfecting in general, COVID specific as well. And you might want to consider using a third party if your crew is not up to the task, or if you have an incident and you need to do a thorough cleaning after an employee has been found to have COVID on site. So you might need a crew to do that. So that's cleanliness, personal hygiene, disinfectant. The last category of best practices is communication, training, and administration. Under the executive order, you're going to have a written plan in place with many of the procedures that I've just described in general. It doesn't have to be in great detail. The executive order provides some thoughts on what you should and need to include. But at a minimum, you want your employees to understand what are the safety standards. You'd like them to understand what it means if they are ill, who they should call, what they should do on site if they witness somebody that's ill. And in particular, the executive order will require you to spell out your isolation plan. Who's responsible? Where will the individual be kept on site until they depart? Under their own power, you give them a ride, or if necessary, 911 responds and you have a first responder that comes in. So you're going to need to have a few things in writing. I'm going to encourage you to be clear and concise, but try not to have, if you don't have to, a 50-page document. I'm going to refer you again to Lear and Magna. Their documents are 50 pages in total because they cover everything, but they have some very nice language in there that gets to the point quite efficiently. Compare whatever you write against the executive order to make sure you've hit the guidelines there, and then you've met the communication standard, or at least the plan standard. Communicate as often as possible with your employees. Knowledge is power. Knowledge is the certainty that they understand what the requirements are. But more importantly, you want a workforce that is safe, educated, and confident to be there. It's just simply part of the deal. It's important to employers and employees to move forward. So with that, I'm going to turn over, see if there's anything else that I needed to address. I already talked about the page. I'm going to turn it over a bit to Brandon. He's going to talk for a few minutes, and then I'll come back.
Thanks, John. Really appreciate the information. One of the attendees had indicated that they were having some problems hearing me by way of the chat box. Can people hear me? John, can you hear me?
I can. Mm-hmm.
Okay. I'm going to assume then that for now it sounds like people are saying that I can be heard. So, like I said, John, I appreciate the information, and some of this stuff is going to be a little bit repetitive, but I'm touching also on areas that don't necessarily have to do with manufacturing. And so some of the portions of EO 2020-77 are specific to manufacturing. Some portions are specific to construction, and some portions are specific to large retail spaces, and others kind of generally apply to any that's running an in-person operation. So rather than trying to address every single specific situation that could potentially arise out there, trying to give some general tips and guidelines, and don't want to cover all the exact same things that John did, but still want to hit some of the highlights. So section 11 of 2020-77 is the section that introduces the COVID-19 preparedness and response plan. And this is a plan that businesses should have in writing that's intended to be consistent with the OSHA guidance on preparing workplaces for COVID-19, which is a document that's around 30 plus pages that John has been referring to on and off throughout his presentation. And I think just the important thing to keep in mind here is that, this document may be worth a read. It's 30 plus pages. But if we keep in mind that a lot of these things are common sense type applications, and they're really geared towards keeping employees safe and operate safely, then I think that a lot of that is going to carry the day. All the things that John mentioned, your standards for facility cleaning and disinfecting, your social distancing techniques, your personal protective equipment and other precautions, and your employee screenings and things like that, some of which is going to get more in detail as we go through here. A lot of the problems that you may experience with workplace drama and with employees being fearful and things of that nature are going to relate directly to the feeling that, you know, the employer or management isn't empathetic to the situation or doesn't care, or that the workplace isn't safe. So, you know, in order to avoid that sort of situation, I think just to underscore what John was talking about, really important to have a transparent plan that's available. And even though there's no legal requirement to, you know, provide a copy to everybody, I think it should at least be accessible to people should they want access to it. And also keeping in mind, you know, that it is about safety. It is about making people feel like they can come to work and be productive in the environment that we're dealing with, and to make that as comfortable and as communicable as possible. And so for purposes of a plan, you know, for example, it's easy to say, okay, we're going to increase our standards for facility cleaning and disinfecting. You know, but what does that really mean? I think it's important to, without necessarily going into a 50-page diatribe on it, to at least say, okay, who's responsible for cleaning what areas? When should it be done? What sort of materials or what sort of cleaning products are going to be available? And we can talk in general terms here without saying that, you know, it's going to be a specific brand or anything like that. But just to say that there's a disinfectant available for employees to use, and employees are going to be responsible for cleaning their own workstations, I think is totally appropriate in this type of situation. John touched on the social distancing, so I won't go through that in too great a detail. And the PPE and physical barriers, you know, in many situations, I think there's a conception that gloves are going to be necessary or helpful. And I think there's certainly some dialogue out there consistent with the fact that frequent hand washing and thorough hand washing is effective. You know, and gloves, when you wear them, you're supposed to be changing them pretty regularly. So, you know, in order to mitigate that type of situation, frequent hand washing is as effective as wearing gloves. One of the takeaways from the OSHA document is the risk classification for employees. It goes from low risk to medium risk to high risk to very high risk. And just on a quick reading of the slide here, you can see that most employees are really going to fall into the lower medium risk exposure. Your high risk and your very high risk exposure employees are typically going to be first responders, healthcare workers, people that are really involved in close proximity with folks that are known or highly suspected of having the COVID-19 disease. And those are going to be situations where you're going to see a full court press. You know, you may see an airborne infection isolation room, full PPE, gowns, masks, gloves, and what I like to call the full court press. But your low and your medium risk exposure workers are going to be folks like, maybe for low risk, you know, people that are working in an office type setting in-house where there's not necessarily frequent contact with the public. You may have some client meetings or some customer meetings in the office, but generally speaking, it's a closed workspace. Your medium risk exposure employees are going to be those that may work in retail or may work in grocery, where they are around members of the public and each other on a regular basis, but these people are not known or suspected of being infected with COVID-19. And this is where the common sense stuff really comes into play, right? Frequent hand washing, hand sanitizer. Employees should be encouraged to stay home when they're sick, encouraging respiratory etiquette, things of that nature. And those types of things for the low risk exposure employees are perfectly acceptable. The medium risk employees, they recommend potentially exploring some engineering controls. So when you go to the grocery store and you see the plastic barriers in between you and the clerk that's running checkout, that's an example of an engineering control that may be appropriate in a slightly higher risk situation. But again, you're not dealing with people that are suspected of or known to have COVID-19. Of particular concern to employees, and I think this is really an area where communication is going to be key, is what happens if somebody, shows up to work or is at work, and whether it's at the beginning of the day or through the course of the day, maybe they develop symptoms of COVID-19, the fever, the dry cough, or perhaps they later find out that they have a positive diagnosis of COVID-19. And this is something that employees are rightfully so fearful of. And so it's important, I think, to have a policy in place that addresses the situation and can help employees to feel at ease that, hey, we're going to be notified if an incident happens, if an exposure event happens. But it's equally important to note that what is an exposure and what is not an exposure. So if you're operating in a smaller type of workspace, maybe a 10-person, 20-person workspace, it may be appropriate to notify everybody that, hey, one of our workers has developed COVID-19 or has developed COVID-19 type symptoms. And that notification, again, would be appropriate in that type of situation. But that doesn't necessarily mean that everybody has to go isolate and work from home remotely, unless that person was in close contact with the individual that was sick. And so that's going to be on management to view and determine who was in close contact with that person while maintaining confidentiality. But confidentiality doesn't guarantee anonymity. So even though you may have a situation where everybody kind of knows who it was, because again, if you have a smaller workplace, everybody may know everyone else's business. But again, that doesn't necessarily mean that the employer is going to go out there and identify exactly who it was that was exposed or was that had the positive diagnosis. So it's going to be important to identify who was in close contact with this worker. The guidance from the CDC and the Michigan Department of Health and Human Services indicates that close contact exists when workers are within 6 feet of one another for a prolonged period of time. And there's really not necessarily a hard and fast rule on what is a prolonged period of time. And there's really not necessarily a hard and fast rule on what's close contact, but a prolonged period of time could be between 10 minutes and 30 minutes. Again, this is direct from the CDC that sources are not necessarily in agreement on how long that lasts. So a lot of employers have gone with a 10-minute rule just to err on the side of caution. But it could potentially be up to 30 minutes in order for a transmission to take place in normal circumstances. Some of the things that have come up in this situation as well are what exactly constitutes a fever. Some states, whether by executive order or potentially by legislation or a public order, have indicated that a fever of up to, or as low as rather 99.5 is considered a fever for purposes of isolating and making notifications. My kid runs a 99.5 fever every time they're running around. If I check their temperature after they're done running around outside, they're going to be elevated. So I don't know how much sense that makes, but for purposes of the CDC guidance, they consider a temperature, a fever, to be subjectively, if you feel feverish, then you have a fever, or if a temperature check reveals that you're 100.4 or higher, then in that situation, you would be considered to have a fever. So kind of naturally flowing from that, the next situation that could come into play is when exactly a sick employee can return to work. So somebody shows up, they've identified that they have a fever, or perhaps the employer actually took the temperature and identified that there's been a fever, dry cough, or something to that effect. The current CDC guidelines indicate two approaches to when employees can return to work. And one involves a COVID-19 test, and one involves a non-test-based strategy. And so, as we're all aware, I think at the moment, the health system is a bit taxed. Tests may not necessarily be widely available. So that's why there's a non-test-based approach, which, consistent with, if for those of us that are in Wayne County, is going to be no fever for 3 days. At least 7 days have passed since the symptoms first appeared, and the improvement of respiratory symptoms. Again, that's going to be the non-test-based approach. And the CDC actually recommends 10 days have passed since symptoms first appeared, but local Wayne County public health order is at least 7 days. And then a test-based approach would indicate no fever, improvement in respiratory symptoms, and 2 COVID-19 negative tests that have been taken at least 24 hours apart. And so many of these areas are areas that involve workplace safety. They involve the executive orders that we've been talking about during this webinar. And I think the next question then, which I'll turn it over to John to address, is what happens if an employee alleges a violation, or if maybe a member of the public potentially alleges a violation? Who's going to handle the enforcement, and what does that look like?
Thanks, Brandon. Just a couple points on this. MIOSHA and OSHA will have the primary responsibility for regulating these new rules in the workplace. But I wanted to make you aware of just a couple of things that we're watching and you should keep on your mind. One, there is some effort that has been publicly stated by the Attorney General, who would like to have a role in workforce enforcement. Some have suggested Michigan State Police. And then at the county level, a number of county executives have attempted to enforce other aspects of other executive orders that have been adopted by the governor. She has resisted those fairly well. Because their executive orders are not codified, they're not long lasting, but it's an indication as we move forward with a new workplace plan, for lack of a better description, there may be things to be enforced. What I want to tell you right now is MIOSHA is preparing documentation to request changes in the rules to adopt many of the things that the CDC and OSHA are recommending. They're staying close as possible to those recommendations, and that's a good thing. Where I get a little nervous, again, is other parties that wish to enter the enforcement area. As an association, we don't think that's necessary. We think that MIOSHA and OSHA already have those designated responsibilities and the ability to enforce as it is. So we're just going to be careful keeping an eye on that. But the other two, excuse me, I did not do a proper sneeze into my elbow there, but I'm not going to see anyone, so everyone's safe. What I do want to keep you aware of is MIOSHA is contemplating asking for additional investigators, and they also want to increase the on-site fines from $7,000 to a minimum of $25,000. As an association, we're resisting both. Please know that we believe they have a sufficient number of investigators already in place, and we believe that the fine, whether you're a small or a large corporation, a $7,000 fine is significant. And what we're trying to argue with them is that it's in the best interest of the employer and the employees that the employees be safe, healthy, confident, and on site. So we're hoping to prevail in that, but that's going to require some time. Just keep your eyes open, and the legislature is going to have to agree to funding those positions. The last thing I'm going to end with, and we'll open to questions, Brandon, is work-share development. Some good news out of the unemployment office, out of the Michigan Labor and Economic Opportunity Office. Director Jeff Donofrio, and his team have been doing a fantastic job trying to mitigate the damage of a benefit that the federal government created for employees, and that was that extra $600 per week kick for folks that are on unemployment. That'll run through late July. And as we start to call back workers in any industry, manufacturing is just one, some of them are making more money being laid off, being unemployed, than they are when they return to the workplace. Jeff Donofrio and his team have worked directly with the feds. WorkShare is an existing program that was created to permit employers to reduce a person's time and put them onto unemployment so that they can still stay employed, has an ability to keep them on the job in a more affordable manner to the employer, but it also allows them access to the unemployment benefits, so they're made whole or close to it in the end. Well, the extra $600 kick changed that whole formula. What we're working out is that if you reduce when you bring them back and reduce their employment by even something like 10%, that makes them eligible for that federal kick and some portion of the state amount, so that when they do return for the period that the $600 extra kick exists, they can still collect that. It reduces the level of concern and probably some level of anger from employees that come back and all of a sudden find that they're working and making less than they were not working. I'm not even going to try to adjust the logic and how it came about, why it came about. It is a hand that was dealt to us. It's not going to change. We just are trying to deal with it. And I'm going to work with Brandon and Andrea after this meeting, and we will get out to you an email if that's possible, Andrea. We're hosting a webinar with Leo tomorrow to go over this specific subject. It is at 10 a.m. It'll be an hour. We'll get an invite so you can participate, and then we'll post it on our website afterwards. It'll go into detail on how you can make WorkShare work in your space. We think it's a phenomenal tool and hope that you can take advantage of it. It just creates a better opportunity to get your employees back happy, safe, without a hassle. So with that quick introduction on it, Brandon, I'm going to turn it back to you.
Thanks, John. So WorkShare kind of begins to address some issues with staffing and operations concerns. And along those lines, I just want to point out that the governor's order does indicate that employers should promote remote work to the greatest extent possible. And so for some businesses, that's obviously going to be doable. And for others, it won't be doable. I think each business is going to have to make a decision whether and to what extent they can promote remote work. But for those that do intend to continue working remotely, or maybe they have some employees working remotely and some employees working in-house, it becomes a question of infrastructure. And I'm not just talking about IT and equipment and things like that, hardware. I'm talking about the legal infrastructure, the HR infrastructure in order to support the remote work. And so questions, more so than answers, but do you have a work from home policy? Does the company have a policy on company owned property and how that's to be treated and what happens if it breaks, different things like that? Do you as a company have agreements with your employees on how they're going to handle or treat sensitive information like client lists or other work related information, whether it might be confidential or non-confidential, but still something that you're interested in protecting? For hourly workers, from the wage and hour standpoint, how are you planning to control costs? As I'm sure we all know, hourly workers have to be compensated for any hours that they actually work, and any hours worked in excess of 40 hours have to be compensated at overtime, the overtime rate of time and a half. So it's going to be important to develop a policy and to communicate that policy with the employees, and then to also have oversight of their work to make sure that you're not making yourself liable for potential wage and hour violations or back wages, or that your employees are honoring what they're supposed to be doing when they're working from home. And the same goes for salaried employees who are supposed to earn their full salary any week in which any work is performed. So in theory, a salaried employee could work one day and maybe entitled to their full salary for that week. So as an employer, are you monitoring your employees to see that, when you're paying them their full salary for the week, are they just working one day, or are they working the amount of hours that you expect them to work? So I think that's going to be important from the aspect of, if you're going to continue remote work in the category of staffing and operations, if you're going to continue remote work, do you have the legal HR infrastructure that's going to support that? John already touched on employee screenings a little bit, but this is an example of what's in the Wayne County public health order, and I'm sure other counties have similar orders in terms of how to screen employees. And so in theory, any no or any yes answer to any of these questions would indicate that the employee should return home. And to piggyback off of the remote work section, the employee, just because they have a diagnosis of COVID-19, they may have mild to moderate symptoms, they may still be able to work from home. So those concerns related to remote work, policies for hourly work and policies for salaried work, all that stuff is going to continue to be relevant even with an employee that potentially develops COVID-19. I did touch on confidentiality a little bit, but just to reiterate, any types of medical documentation should be kept separate from a personnel file and should be kept confidential. Any employee that discloses medical type information, that should be treated confidentially and again maintained separate. For screening purposes, it seems like in keeping with the confidentiality requirement, it makes sense to do those in private to the extent possible, or to keep them confidential as best as you can. Now this topic, leave time, could be a webinar hour plus in and of itself. I don't want to do that to you, so I'm just going to blow through some of the highlights really quickly, but things to think about: whether somebody has a condition, COVID-19, or whether it's a different condition, employers still need to be aware that the regular PTO policies, the Families First Coronavirus Response Act leave time, regular FML leave time, and accommodations under the Americans with Disabilities Act would still potentially be applicable. So it's going to be really important to keep those things in mind. And for purposes of the Families First Coronavirus Response Act, that's going to apply to any employer with fewer than 500 employees. So a pretty good majority. I would anticipate that probably being most people in this webinar. So a resource for that would be if you'd run an internet search for DOL, as in Department of Labor, questions and answers. There's a gigantic document with 80 plus questions and answers on Emergency Family Act and the Emergency Paid Sick Leave Act. I recommend that if you have between 1 and 499 employees, that you go read that, because it provides a lot of good information on how to protect yourself from a potential claim that you didn't handle a leave time request properly. One point of confusion is that the regular FMLA still applies. So the normal FMLA rules will still apply to your business if you were qualified prior to the Families First Coronavirus Response Act, which would be 50 or more employees, rather than the 500 or fewer employees standard in the FFCRA. But somebody does not get emergency family medical leave for 12 weeks and then also get regular FMLA for 12 weeks. It's one FMLA entitlement, and you may use it as part of the Families First Act or as part of the regular FMLA provisions, but you don't get both. Now, there's a lot of contention over various issues related to work schedules, remote work, employees that may be fearful to come into work because of COVID-19 concerns, because they're worried about bringing things home, maybe to their family from in-person operations. And I think it's important to know what a disability is exactly, what a medical condition is exactly, and what it's not. So regular fear or anxiety surrounding COVID-19 is probably not going to be something that the ADA or the Michigan Persons with Disabilities Civil Rights Act is going to require you to accommodate. But in the event that somebody does have a medical condition, case law and the ADA regulations both indicate that remote work and modified work schedules or leaves of absences are all potentially reasonable accommodations. So those are all going to be things that probably you should work with HR and work with counsel on, because each situation is very fact specific, and each situation is going to stand on its own as far as whether or not it's a situation you should accommodate. But the important thing is to engage with an interactive dialogue with the employee once they raise the concern, to determine if they have a medical condition that qualifies and whether or not the accommodation they're requesting is going to be appropriate. Because employees aren't entitled to the accommodation of their choosing, they're just entitled to a reasonable accommodation. So management is going to have some discretion in that respect. And this is another area where it could be its own webinar probably. But many private sector employers that are non-union shops don't understand that the National Labor Relations Act does apply to them. It applies to most private sector employers. And so the gist of it is that workers have a right to engage together regarding issues pertaining to wages, hours, and terms and conditions of employment. So, you've seen situations where workers will get together and walk off the job. Things like that could potentially be protected activities. And so as an employer, if you discipline or discharge an employee for engaging in those types of protected activities, you could be on the hook for an unfair labor practice and some really potentially gnarly negative media attention. So those are things to keep in mind. And because COVID-19 is a safety issue and because it raises concerns about how workers are treated and things like that, I think there's an anticipation that unions are going to probably use this as an opportunity to try and get into workplaces that they may not have been in before, and to try and use this as an organizing opportunity. And so to the extent that you can have clear and consistent communication about the workplace safety issues, I think that's going to go a long way towards keeping your employees happy and turning them away from potential union organizers. And so with that, I will open it up to a couple of questions. I did have a couple of questions that seem to keep popping up with different clients. So I'm going to go ahead and address those first. One question was, what if an employee refuses to return a report to work? And, you know, a lot of times this is simply because the employee is refusing to report to work because they're afraid, or maybe they're making more money on unemployment. And so as an employer, what you need to be aware of is that there could be potentially protected reasons why this employee is not reporting to work. So it's going to be important to obtain some type of written statement from the employee, understanding her reasoning for not wanting to return to work, and then to analyze whether or not that statement indicates some type of protected category. Maybe it's a disability, or maybe it's an FMLA type issue. Whatever the case may be, it's something you want to take a look at before you make an off-the-cuff decision. And then if the employee's reason is not a protected reason, then I think the next step is to simply make a business decision. And does it make business sense to make some type of exception for that employee, or to make alternate arrangements? Does the employee qualify for remote work under a policy that you have, or does the employee qualify for an alternate type of work schedule or something to that effect? And I don't know if anybody can still hear me. I seem to have lost my presentation. Okay. Well, for whatever reason, I lost my presentation. I don't know if you guys can still see it, but I'll go ahead and move on to the next question that I got, which was, what about an employee who refuses to follow procedures, such as wearing a face covering or maintaining social distancing? And this is a workplace policy, just like any other type of policy. The COVID-19 Preparedness and Response Plan can be enforced the same as any other workplace policy could. The only thing to keep in mind is that somebody may, for example, not be wearing a face covering due to a medical condition, so there could be some potential reasonable accommodation issues there. But generally speaking, you as an employer have the right to discipline, discharge, or treat it as a training opportunity. Because this is a safety issue, it may make sense to initially take this as an opportunity to retrain the employee or counsel the employee on the effects that their actions or lack of following the procedure is having on others. But at the end of the day, it's going to be a business decision as to whether or not some type of disciplinary action is going to be taken. So I'm just scrolling through here to see what questions. Okay, so I seem to have my presentation back, which we're towards the end of anyhow. So somebody asked, is there an actual list of essential businesses? The answer is no. There's not necessarily a list of essential businesses. And that might be a little bit of a misleading term because the terminology typically used is whether or not it's a critical infrastructure worker. So there are a list of, in Executive Order 2020-77, there is a list of industries that are identified as critical infrastructure industries, but there's certainly some ambiguity there and some arguments to be made either way as to whether any particular business or any particular worker is an essential or critical infrastructure worker. And the other reason that that might be misleading to use that terminology is that there's other activities that are identified as resumed activities. So those are things like real estate services, construction, operations, manufacturing operations, and remote or curbside retail type operations. So all of those things have been allowed to continue as of the executive order, but there's also moving and storage operations for people that may be moving from one home to another. But there's no actual official list of essential businesses that would be controlling. I would just have to refer you to Executive Order 2020-77 to see what it says in regards to your specific circumstances. Okay, so one question regarded if somebody refuses to return to work because they feel they're at high risk. The Centers for Disease Control and Prevention does have a list of conditions that could potentially place somebody at high risk. So I think the important thing here is to remember that with the Americans with Disabilities Act and with the Persons with Disabilities Civil Rights Act in Michigan, it's important that if an employee makes a request for an accommodation, that the employer engage in the interactive process with the employee. And, you know, can you require a doctor's note? Yes, but there's more to it than that, because you need to understand what their limitations are. Can they still, even if you do provide a reasonable accommodation for them, can they still perform the essential functions of the position? If they can't, if with an accommodation they still can't perform the essential functions of the position, then they're not really a qualified individual with a disability. To the extent that there is any discussion over the medical issues involved or the limitations or any requested medical documentation, those documents are confidential type information that does need to be kept in with medical records away from the personnel file. Another question: if an employee was diagnosed, can an employer require a doctor's note to return to work? Current guidance from the Equal Employment Opportunity Commission regarding the Americans with Disabilities Act indicates that employers can require temperature testing. They can require COVID-19 testing. It may be the case that the doctor wants some type of limited waiver or release in order to release that information, but that's certainly an option that's available to employers. I don't know what the availability of testing is, but it's out there. It's out there, and it's been indicated as appropriate by the Equal Employment Opportunity Commission. Okay, I'm not seeing any other questions in the chat box. Please, we really want your feedback on this to see how you think we did, whether you thought this was valuable. I see somebody indicated they thought it was good information. I really appreciate that. We will be sending out an email with some further information from you. We're going to collaborate with John on the webinar tomorrow, and whether that's something that we can get out to you guys. If anybody has any information, I'm going to put my personal information up on the screen here. And when it pops up. Okay, so you can call or text me at 734-956-0113, or my email address, if that's hard to see, is bgrysko, bgrysko @fb-firm.com, and I'd be happy to help you out any way I can. Again, really appreciate you guys attending. It looks like John had to jump off, but I appreciate John coming out and sharing his perspective with us. I thought it was really valuable information that John was able to give us. And again, if there's any follow-up questions or anybody needs anything, please feel free to reach out to me. Thanks, everybody.